I'm David DeLugas, the $99 lawyer, and today, on my birthday, I'm going to answer another question. This week's question has to do with what do I do if in business with some partners we have some real management disagreements and problems, either about how to operate the company or how to divide the profits. Well, let me answer that question. Most importantly, look for the documents that describe your arrangement. If it's a partnership, there should be a partnership agreement. If it's an LLC, there should be a membership agreement. If there is a corporation, there should be articles of incorporation and bylaws. Every organization should have organizational documents that spell out different things having to do with power, authority, and ownership interests. So, often I hear people say, well, I'm a partner in this business. Well, what's the name of the business? It's XYZ Inc. Well, if it's a corporation, you're not a partner. What you may feel like you're a partner, but what you are is a shareholder, and the shareholder interest defines the ownership, but the management of the company is determined by the board of directors, who are elected by the shareholders, and then the board of directors appoint the president, chief financial officer, chief operating officer, the secretary, and the treasurer. Each state law determines what offices must be held, which ones can be held by the same individual. And again, if you have a partnership, there should be a partnership agreement. Now, for most small businesses, probably the most important document is for a corporation called the shareholders agreement. And for an LLC or a partnership, it'll be something on the form of a partnership agreement or a member agreement. And what this would say is, what do we do? What happens when we have a falling out? Sort of like the prenuptial agreement in businesses. This is what happens when we don't get along anymore. We're getting along great right now as we're forming our business or as we're taking off and things are going well. But when we hit a roadblock, whether it's a financial problem or whether it's a greed issue or whether there's malfeasance, somebody just screwed up or somebody stole, what do? First of all, don't run away from your problem. Don't resign your position with the company. Don't just leave. Don't feel as if you need to step away and get out of it in order to save yourself. It may be true that you need to get away, but you need to do so in accordance with the corporate organizational documents, the bylaws, the shareholder agreement, the member agreement, and the like. Otherwise, A, you may be forfeiting a great deal of your interest, financial interest. B, you're giving up control. And C, you may actually find yourself more liable because of your fiduciary obligation to other owners, other shareholders and members and the like. So, I guess the most important thing to get across to you is this isn't a lemonade stand on the corner with your friends. If you're in business together and things are not going well, resort to look at the corporate documents, the membership agreements, and the like. Now, what you make of those? Hopefully they're done. If you haven't had those done, now's a good time to try to get them done. Get with your partners, the other people that have an ownership interest, however it's defined, and the other operational people of the corporation, entity, business, and work on those. Try to get those together. And if you end up going to legal counsel, make sure whatever attorney you hire knows whether or not that attorney is representing the company or representing individual owners or representing individual management positions. The president may also have an ownership interest, but perhaps is coming to the attorney as the president of the company seeking advice or advice on behalf of the company. So those should all be well defined. Again, the important point for you to take away from this is if you're in a small business, family business, business with people who were your close friends, try at the outset when things are going well to come up with the proper documentation that covers all of the situations. Often in a small business, if one person were to die or leave for some reason and want to sell their interest in the business, the other owners may want to first write a refusal to purchase those shares or the partnership interest or the LLC member interest, rather than have that go to a spouse, particularly if in a matter of a divorce or a death, because you don't know if you're going to get along with that other person, the person who has not been part of the original group of owners or managers, or somebody who had, say, some knowledge, skill, or ability that contributed to the success of the company. But you may not want to pay fair market value. You may want to pay a reduced book value or some other number. So these are the things to get done as early on as you can in the business as it's being formed, or if you're already in business and while things are still amicable, try to get everybody together and get these documents put in place covering all of these different bases. Now, it can be done. It possibly can be done without the use of an attorney. I do advise in situations like this that you get a good attorney, business attorney, or a business attorney litigator, because the thing about those who are trial lawyers, we know where things have gone wrong and know how to protect against those same elements coming up in a bad way at a later date. So I hope this has been helpful. If you'd like more information or you have specific questions about your business and your relationship with your partners and fellow shareholders or operational people, your friends, your family members, book a session with me, the $99 Lawyer. And hey, happy birthday to me. Thanks.